Good afternoon, everyone. I just want to thank you for your patience as we get a few additional people on the call, and they continue to come in, and so we want to make sure we accommodate those all as well as possible. But in respect for your time, as it's now just a little bit after 1:30, we'll go ahead and get started on the call. Good afternoon. My name is Matt Morrow. I'm president of the Springfield Area Chamber of Commerce, and just want to thank you all for joining us today and being a part of this call. As always, our efforts at the Chamber are really being driven by feedback from our members, trying to bring you what you need right now to navigate the COVID-19 pandemic, and particularly the economic impacts on businesses that are related to our response to that. You are, as our members, informing all of our strategic action and advocacy efforts. And last week, we were able to provide an overview of the CARES Act to nearly 300 members from a U.S. Chamber expert, because learning more about federal policy was a top need of our members at that time. And another significant issue that is really impacting businesses today is trying to navigate the landscape for employers and employees related to labor needs in this really unprecedented time. This crisis is just having a tremendous impact on businesses in every possible way. And so many of you have really reached out to us with your employment concerns, especially in the last week or so. So today, it's really our hope to provide some helpful information on that. And we're so glad to bring you this program in partnership with the Springfield Metropolitan Bar Association. Today, we're joined by Krista Hogan, who is Executive Director of the SMBA. And I'd like to thank Krista for lining up the experts from Spencer Fain that you will hear from in just a moment here on this call. So we're glad that you're able to join us today for this opportunity to overview some of the employment issues and then address some of your specific questions. We're going to go to Krista in just a moment. Before we do that, just a little bit of housekeeping. We've captured questions that were submitted in advance, and we will try to get to most of those questions today. Additionally, if you have a question that comes up during today's presentation, if you would, just please email that question to Lauren Musto on our team. That email address is lmusto@springfieldchamber.com. Again, that's LMUSTOE at springfieldchamber.com, and we'll do our best to get all of your questions answered. And for any that we don't get to today, we will work to find answers to those as well and just follow up with you personally to the extent that is possible also. Additionally, you should have received the PowerPoint today via a reminder email just a short time ago, a little bit earlier today, so that you can follow along with our speakers as they walk through some of the highlights that you'll be. Again, you can follow along in that PowerPoint, but if for some reason you can't locate that email, you can also find the PowerPoint posted on our website on the COVID-19 page where this event is listed. So you need to go to springfieldchamber.com and click on the calendar, find the calendar invite. You can download those slides that way as well. If you did get that email, that's also the same email that you can send your questions to. Again, lmusto, LMUSTOE at springfieldchamber.com. So before we start, I do want to mention that our guests' comments today are not intended to be considered direct legal advice for your business or to you personally. This is really meant to serve as an overview for general questions that are coming frequently and that we have been hearing from our affected members. Certainly, we always want to recommend that you consult your own legal counsel, your own attorneys for those questions, and really make sure that you have precisely the right answers for your business. So at this point, I'd just like to take a moment to turn over things to our friend Krista for a brief update and to introduce our guest speakers. Krista Hogan, are you there?
I am. Can you hear me?
Sure can. Go right ahead, Krista.
Thanks a bunch, Matt, and thanks everyone who's joining this call. The Springfield Bar is proud to partner with the Chamber to help get this information out to area employers. I'd like to reiterate what Matt just said and caution you not to consider the information as formal legal advice. This is a complicated and dynamic field, and I encourage you to consult with your attorney if you feel like you need help navigating the issues, but you're also welcome to contact our speakers following today's call. For those of you who don't currently have existing legal counsel, I would advise you that the Springfield Bar set up a panel of attorneys through our lawyer referral service. These attorneys have agreed to provide an initial brief consultation at no charge to assist the Chamber members with their COVID-19 employment law questions. Please send your requests for consultations to that same email that Matt just mentioned, lmusto@springfieldchamber.com. As Executive Director of the SMBA, I get to work with exceptional lawyers who live and practice in the Springfield area, and I'm pleased to introduce two of them to you. Elizabeth Wente is a partner at Spencer Fain, specializing in labor and employment. She assists employers with such matters as implementing sound practices, conducting employee training, advising human resource departments, and much more. Paul Satterwhite, also a partner at Spencer Fane, specializes in healthcare, labor and employment, and higher education. He helps clients navigate employment law and develop strategies for negotiation. Paul has considerable experience providing labor and employment counsel in corporate transactions. He's also a member of the SMBA Board of Directors. Both Paul and Elizabeth are experts in their field, and they have been hard at work navigating the legal landscape of COVID-19. Elizabeth and Paul, I'm going to turn this over to you now with my thanks for your willingness to share your wealth of knowledge in what I know is a crazy busy time for all employment lawyers.
Thank you, Krista. This is Elizabeth. I'm going to jump in because I'm going to kick off our presentation. I want to first start out by thanking everyone who is on the call today from both Paul and I and all of us at Spencer Fane. We recognize that this is a difficult time for all employers, and especially the small employers across the United States and in our community. So this is the very least we could do for you all at this point in time, is to try to give you the most up-to-date advice that we can. As many of you are aware, I'm sure, this is, the issues relating to COVID-19 are constantly changing. And as several of us have discussed in the past few weeks, it's a little bit like drinking from a fire hose. So if you feel like that, know that you are not alone. We all feel a little bit like that because there is a lot of information coming at us from a lot of different directions. So Paul and I are going to spend some time today to try to boil down to a few specific issues that we think will impact small employers the most. We have incorporated, as Krista and Matt mentioned, some of the questions that you all submitted, and then we'll be answering some of those on the back end of the presentation. The discussion that Paul and I are providing right now is just a bit of an overview. So I'm going to jump in and speak a little bit about the Families First Act, and then Paul is going to talk a little bit about the unemployment pieces, just to give you some background. So for those of you that have the slides in front of you, the first one really just is an overview. So as many of you know, there are kind of two large pieces of legislation that have come out in the past few weeks that have direct impact on employers. The first was the Families First Coronavirus Response Act, which we will refer to today as the FFCRA. And that act covers emergency FMLA and paid sick leave. The second is the CARES Act. And the CARES Act is where the federal government kind of came in and gave our unemployment system a boost, shall we say, through the form of the Pandemic Unemployment Assistance and the Federal Pandemic Unemployment Compensation. So I'm going to give you a very brief overview of the FFCRA. If you all, we're kind of assuming that everybody is somewhat familiar with the FFCRA, so this is just high level. At the end of the slides, you'll find a resource page that has links to several resources, including the Spencer Fane COVID-19 page, the Department of Labor FAQs, and the IRS FAQs, which are really good resources that you can go to kind of get some of your more basic answered. So as a brief overview, the FFCRA, the first thing it provides is emergency FMLA. And this is a bit unusual because most of the time small employers, those employers that have under 50 employees, do not have to deal with FMLA. So this is kind of a new ball game for small employers, so I want to highlight this piece. The emergency FMLA, an employee to be eligible for that only has to have worked for the company for 30 days. So it's a very brief window of work required for the employee to be eligible. However, there is only one reason that an employee can take emergency FMLA. And the one reason is that the employee is unable to work or telework, meaning work from home, because the employee needs to care for their child whose school or place of care or child care is not available because of COVID-19. So there are some really specific details around this piece. A couple of them, the employee has to certify that there is no other suitable adult that's available to take care of that child. So for instance, and if any of you have a significant other like this, just forgive me. If your significant other says, I just can't handle taking care of the children because I don't want to, that's not going to qualify as a suitable, as a reason to not have that person stay home with the child. So keep in mind, this is a very, very narrow reason that an employee can take emergency FMLA. If the employee is eligible and does have a qualifying reason, the benefit is that the employee gets to take 12 weeks of leave. This is to be combined with any other FMLA. So if you are an employer who does have to provide FMLA for other reasons, this is a total of 12 weeks for any regular FMLA purpose or emergency FMLA purpose. It is not 12 weeks on top of the regular FMLA. So within that 12 weeks for emergency FMLA, the first 10 days of that are unpaid leave, and we'll talk about why that is in just a minute. But the remaining amount of leave that the employee takes is paid at 2/3 of the employee's regular rate. So again, this is one of those pieces, the emergency FMLA. You receive tax credits for the benefit that you provide, assuming that you put together the proper documentation. So again, we're just covering this at a very high level. So I'm going to switch over to the paid sick leave that's available under the FFCRA. So this is a separate benefit than the emergency FMLA. And the paid sick leave is a little bit of a broader benefit, honestly. There are a couple of different qualifying reasons that an employee could take the paid sick leave. And we've kind of explained them in the form of two different categories. So category one of the qualifying reasons is that the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. The employee is advised by a healthcare provider to essentially stay home, self-isolate due to COVID-19 related concerns, or the employee is exhibiting symptoms of COVID-19 and seeking a diagnosis. So those are your category one reasons. Your category two reasons are that the employee is caring for any individual that is subject to federal, state, or local quarantine or isolation related to COVID-19, that individual is advised by a healthcare provider to self-isolate or self-quarantine due to COVID-19, or that individual is exhibiting symptoms of COVID-19 and seeking a diagnosis, or the employee is caring for their child whose school or child care provider is closed or unavailable due to COVID-19. So if the employee has one of those reasons, they will qualify to take this paid sick leave. This includes both full-time and part-time employees. And the benefit that's provided here is paid leave. And so the way that it works is that for purposes of the paid sick leave, a full-time employee is anybody who is regularly scheduled to work 40 or more hours in a given work week. So even if you as the employer, you have definitions of full-time and part-time that are different, that doesn't matter. For purposes of this paid sick leave, this is the definition of full-time that applies. 40 or more hours equals full-time. Those full-time employees get 80 hours of paid sick leave. If the employee is a part-time employee, meaning they work anything less than the 40 hours, their time is prorated. Their hours that they receive are prorated based on their part-time work. So with that, the pay is also a bit different. Depending on the reason that an employee takes paid sick leave, if it's one of those category one reasons, the employer then has to provide 100% pay. If it's a category two reason, the employer provides 2/3 pay for those paid sick leave hours. So it's a little bit confusing, but we've tried to break it down as simply as possible. The other piece on the paid sick leave is that this is another benefit where the employer gets that dollar for dollar tax credit. So it's really important when we're looking at these benefits that if you're taking advantage of them, and you should be, and if your employees are taking advantage of them, which they should be, that you're collecting the necessary documentation to support the tax credit, because you want to make sure you're getting that tax credit on the back end. And we can talk a little bit more about the tax credits. I think one of our questions addresses the documentation. So a couple of things to highlight for small businesses for FFCRA purposes. There is an exemption for small employers, but it's very specific and it's pretty narrow. And quite frankly, I think the way that it currently stands, this is going to be an individualized assessment on a case-by-case basis each time you get an employee that requests this leave. So this isn't a situation where the small business can say, hey, we're a small employer, we have less than 50 employees, we're completely exempt from the FFCRA. That's not how the exemption works. So you have to be looking at this for a couple of things. First, the employer has to have 50 or fewer employees. Second, and I believe I have a correction on the slide that I need to make, so I apologize for that. I will send out a revised slide here. But second, the employer has to show one of these three reasons that's listed on this bullet point, on these bullet points. Essentially, that the leave results in causing a financial obligation that's going to exceed what the company can afford. Or the employee's absence creates a risk to the financial health or operational abilities of the organization. So this would be like if you had a key employee, a CFO, or someone like that needed the leave. You could argue their absence is going to create a significant risk to the continued operations of the organization. And third, that if that person takes the leave, there aren't enough workers that would be available to be able to fill that role. And then the other piece of this, and this is the piece that I believe is left off this slide, is that the reason that for the exemption is you can only have the exemption taken when an employee is asking for the leave to care for the child that's out of school. So it's a pretty limited out of school or doesn't have childcare. So it's a fairly limited exemption. And honestly, that makes sense if you look at it, because if you have somebody that's suffering from a COVID-19 issue themselves, you don't want them in your workplace anyways, because you've got potential exposure there. So with that said, I'm going to turn this over to Paul. And well, oh, I'm sorry, there's one more piece. There's no civil liability for employers that have fewer than 50 employees. Honestly, I don't anticipate that would be a situation that you're going to see a lot of issues about anyways. But I'm going to turn it over to Paul now to touch on the unemployment benefits, because I think that's where a lot of the questions and concerns arise, especially with this group.
Paul, are you there? Hold on for just a second. We'll try to make sure that we get Paul on the line. Hold there.
So Ryan, I can keep talking until he joins us, and then he can take over. That way we don't have a lull.
That might be better.
Yeah. So let me jump into the unemployment piece here. So there's kind of the unemployment piece that came through the CARES Act. It gives us kind of a new way to allow our employees to receive unemployment. So you still have the avenue that if an employee was eligible for unemployment under Missouri laws, they would be entitled to get unemployment as usual. But we also have this new COVID-19 related method. So those situations arise where an employee would not otherwise be eligible to receive unemployment, but because of a COVID-19 specific reason, they are now eligible. So there are about 9, I think, specifically articulated reasons that are considered quote unquote COVID-19 related. But it's important to remember that we now have this other method of obtaining benefits. So let's talk about the first option we're referring to as option A here, which is the normal eligibility for state unemployment benefits. Those of you that haven't had to deal with unemployment benefits very often, this is just a very high level review. So under normal circumstances, an employee is eligible for benefits unless they were discharged for misconduct, they resigned without good cause, unless they are not ready or available to work, or unless they have an insufficient earnings history. So those are the circumstances when employees would normally be eligible to receive benefits. Option B, the COVID-19 related benefits, which is also referred to as the Pandemic Unemployment Assistance, PUA. In those situations, these are the reasons that are COVID-19 related that an employee would be eligible for unemployment. So if they would otherwise be able to work and they're available to work, except that they're unable to work because of one of these 11 reasons, and those are articulated in the PUA. If you're interested in what those specific reasons are, you're welcome to shoot me an email. I'm happy to send you those reasons. It's just a lot to put on a slide. And then number two, and this may be important for many of you, if you're self-employed and seeking part-time employment and you don't have sufficient work history or otherwise would not be eligible to receive unemployment benefits under Missouri law, and you have one of those COVID-19 related reasons, you can actually get unemployment under this PAU, the COVID-19 related unemployment. So a couple of other things to keep in mind about the COVID-19 related unemployment and for the PAU. The duration is as long as unemployment or inability to work continues because of COVID-19, which is, there are a lot of these laws that are kind of vague. This is one that actually benefits us because we don't know exactly how long this is going to go on. Number two is for the number of weeks that the individual is not entitled to normal unemployment benefits. So it could add on. Number three is for weeks beginning on or after January 27th, 20 and ending on or before 12/31/20. So this is just a benefit that goes through the end of this year. And then it's a maximum of 39 weeks. Paul, have you joined us? No. Okay. So some things, some exclusions where the person is not eligible for benefits. And this is going to be important for those of you that have organizations where telework or remote work is available. If you have employees that can perform their work remotely, they are not going to be eligible for unemployment benefits. Or if the employee is receiving paid sick leave or some other paid benefit, so it's one of those benefits under the FFCRA, or if your organization is just giving another paid benefit, the employee will not be eligible to receive unemployment in those situations. So what is the amount of benefits? And this has been kind of the question for everybody lately when it comes to unemployment. So the amount of benefits under either receiving unemployment under the normal state laws or under this COVID-19 special reasons, the PAU, the employee is going to receive the normal weekly unemployment benefit under the applicable law. So that could mean full unemployment, it could mean partial unemployment in some situations. On top of that, the government under the CARES Act has also given us an additional federal benefit called the FPUC. The FPUC is that additional $600 per week benefit. And the way that the guidance currently reads says that if an employee receives even $1 of unemployment benefits, they're going to get that $600 per week benefit. And that $600 per week benefit is available through July 31st of this year. So
hey,
oh, great. Hi, Paul.
Oh, Elizabeth, I made it back on. So I appreciate you jumping in and taking over. Absolutely. And my apologies to everyone who's on, and thanks to Elizabeth for picking that up. I don't know what happened on my end, but I got shut out. But I do want to move pretty quickly through this issue. I think this one slide that Elizabeth's hitting on right now is answering a number of questions that we've gotten from clients. And this was just buried in some unemployment guidance that this $1 number, where if an employee is eligible for $1 in the underlying benefits from the state, that they're going to get the full 600 is the key to both the questions your employees are asking and some of the issues you're going to face with employees over the next few weeks and months. As unemployment's getting its day in the sun, you're going to see a number of issues in getting folks to work, and we'll talk about some tools with the the state has given you on that issue. I also want to get to your question, so we'll move pretty quickly past this. One thing to think about here, though, is that $1 is pretty important because someone can have reduced hours and not get $1 of eligibility under the state rules or under the federal rules. And in that situation, we're looking at a situation where they'll be unemployment eligible, but not eligible for $1. They won't get the $600. That's a key piece of the analysis. If we look at this next component, this is a guidance that came out on Friday evening on Easter weekend, and this addresses the additional 13 weeks of federal funded benefits. It's known as the PEUC, or Pandemic Emergency Unemployment Compensation. So it's added on to the 20 weeks in Missouri where an employee is eligible for regular benefits, and it is not added on to the 39 weeks under PUA, but the qualifications here, there are 4 bullet points. Employees have to have exhausted all of their rights to regular compensation under state law, and then they have to have no rights to regular compensation with respect to a week under any other state law, and it even looks at Canada's unemployment if they're eligible for unemployment under Canada's unemployment. And then they have to be able to work, available for work, and actively seeking work, although states have to offer flexibility on actively seeking work where there are COVID-19 impacts and constraints. And this answers the questions we've gotten from a number of folks. How does that 13-week add-on work? And so these are the qualifications that employees will have to meet to get additional compensation above the 20 existing weeks under Missouri law. Some of the other key issues, the waiting week is waived. And that waiting week, the 1 week that employees typically have to wait for unemployment eligibility, is waived through December 31st of 20. The FPUC, or as it's being used in abbreviations, and I know there are a ton of acronyms in this area of the law in the last 3 weeks, but that $600 a week is going to be paid weekly, or it can actually be a part of the unemployment benefit, or it can be a separate payment. It's not entirely clear how Missouri is going to do that yet, although they have said they're going to start making those payments this week. And then we have the shared work and work sharing programs, and that's one of the biggest issues that we're waiting to see exactly how it works. We believe that under the work share programs, the $1 will be triggered and the $600 will be paid on top of the work sharing programs. And a number of our clients are working on putting together those work sharing programs. We're not going to go into detail how those programs work in this presentation, but the basics of it are that you complete an application with the unemployment or with Employment Security Division, and in that situation, after you've completed that application, you can reduce pay to 80% or as low as 60% of employees' pay. And it's a much more detailed program than we can get into here, but it is attractive for a number of the employers that we're working with. The biggest question we're getting is, what about employees who want to quit to try to draw the $600 FPUC payment? And the state of Missouri is being very clear on this issue. And it's their first question in the question and answers, which we've provided in these materials. If an employer offers sick leave and or other leave or remote work options to address COVID-19, then a person who quits on their own volition will not qualify for unemployment benefits. The guidance from the federal government has been that the good cause for quitting rule applies, the same that exists at the state level, and that quitting without good cause to obtain additional funds under regular unemployment program or under CARES qualifies as fraud. If an individual obtains benefits through fraud, the individual is ineligible for any additional benefit payments, must pay back the benefits received, and is subject to criminal prosecution. State DOL has gone so far as to provide a poster that they're allowing or providing for employers to post in their workplace. This is not a required poster, but it is an optional poster that they're providing to employers who have concerns about employees who may try to quit or may try to, through other efforts, to get this additional $600 benefit. We've provided that poster in the materials. You can get that poster also through the question and answer materials that we've provided in these materials. If you turn to that next slide, this is the link to the Q&A. That link will provide you with a number of questions that are out there for both employees. So you can provide this to your employees who have questions about unemployment. It also gives employers some great guidance, covers some of the issues we've covered here, gives the link to the poster that you can post in your workplace that will discourage folks from from quitting without good cause. If you go back to that poster for just a moment, the first bullet point is the key, and it specifically states that if workers quit a job without good cause, they are not eligible for unemployment insurance benefits. And the part that many of you have probably been waiting for, quitting a job due to fear of exposure to COVID-19, absent advice from your healthcare provider, is not considered good cause for quitting under the law. If you go to the bottom of that poster, specifically states in the next to last bullet point, if a workplace is operating during COVID-19, workers should provide a doctor's note when filing for unemployment. The note should explain what work the employee can perform. That puts a significant burden on the employees who have work available to them and are choosing not to work. They need to be relying on a medical provider for that purpose. We have a resource page. We have some DOL FAQ and our IRS FAQ that we've provided the links to, but I think we've reached the point in the program where we'd like to move to your questions and answers, and I'll kick this back to Matt to start that process.
Well, Paul, thanks so much. And Elizabeth, I mean, you have just done a tremendous job here. In fact, you've anticipated many of the questions that we've received, but I may revisit a couple of those just to clarify and make sure that that we're hearing you right on some of that. And you touched on this just a moment ago, Paul, about a lot of questions you're getting around shared work specifically. So and we've received a lot of those also. So if a company, if I'm hearing you right, if a company is using the state's shared work or layoff mitigation program, are employees eligible? So employees, you're saying we think employees are eligible for the $600 additional weekly unemployment being provided through the CARES Act, and is that a partial benefit? Is it not at all? Is it the whole benefit? What is that specifically?
And Matt, as we're reading it, and we do caution this that there's new guidance coming out all the time, but as we read it in the guidance from the federal DOL to the states, it says if $1 of eligibility exists, if the employee is receiving $1 of state benefits, they will be eligible for the $600. Under the work share programs, which are also anticipated, encouraged, and partially being paid for by the CARES Act, the CARES is looking to pay states to set up work share. Under the work share program, employees are eligible for $1 or actually significantly more through those programs. So as we read it, they should be eligible for the $600. What I have told clients who I'm working with on this issue is the proof will be in the pudding. We'll wait and see what happens. If the employees receive the $600, we'll get our answer. There is no mechanism for prorating. There is no mechanism from either the CARES Act, the guidance to the states, or anything we've seen in the Missouri guidance that has come out for prorating an amount. So I anticipate it will be $600, but until those checks start coming out this week or the direct deposits, it's not entirely clear.
So that's actually consistent with the guidance that we've been receiving from Department of Labor also. But like you said, because this changes so rapidly, we'll really know for sure when those first checks start arriving. Maybe a quick follow-up on the work share program for Paula, or this may be for Elizabeth, whoever's maybe best suited for this. For people who aren't as familiar with that specific program, and you probably wouldn't be until you started down this road, is that a program strictly for hourly employees? Is it for exempt and non-exempt employees alike? How do you utilize work share, and who's eligible for that?
Sure. Matt, this is Elizabeth. I'll jump in and take this one. So the short answer to the question is yes, your exempt employees or associates absolutely can participate in the shared work program. So just to make sure we're all kind of using the same language here, oftentimes people refer to exempt employees as salaried employees and non-exempt employees as hourly employees. The exempt and non-exempt are the classifications that we use under the Fair Labor Standards Act. So when we talk about exempt employees, usually those are your salaried employees. And they can be participants in the shared work program, but there are a couple of things that you have to keep in mind and be cautious about when you're looking at having an exempt employee participate in one of these programs. So it's really important when let me back up. As part of the shared work program, you will have to reduce the hours that the employee is expected to work. That's how the employee will receive unemployment. So in correlation with that, we need to reduce the employee's salary. And anytime you go to reduce an exempt employee's salary, it becomes a little questionable, because the whole idea of an exempt employee is that they are supposed to earn the same salary consistently across work weeks, no matter how much time they work, honestly. And those of you that are small business owners know that. But so when you go to reduce their salary, you need to make sure that you don't reduce an exempt employee's salary below the $684 threshold. So they need to be making $684 per work week, and you need to make the reduction in expected hours. So, for instance, if you are going to reduce an exempt employee's salary by 20%, you would also message and change the expectation of hours worked to be 20% fewer than the normal expected hours. This is something that you have to be careful about when you're doing, and make sure that you're messaging it appropriately. You also want to make sure that when you're making this reduction, you're not reducing the salary and changing it week to week, depending on how much work is available. Reduce it per the terms of your work share program by a certain percentage, reduce the salary, reduce the work hours, and then keep it at that amount, so you're not fluctuating between work weeks.
Great insight. Thank you for that, Elizabeth. We also had several questions specifically sort of around trying to navigate the number of weeks of Missouri unemployment that's available, the 13 extra weeks of federal government requirements for is that a maximum of now 33 weeks for COVID-related unemployment, or is that additional 13 only for the COVID-related portion of the layoff? Paul, I may just go to you on this because you talked about this a little bit. Could you just walk us through in as simple terms as possible what the number of weeks in question are for unemployment and kind of how that breaks down?
Sure, Matt. And it is confusing, and I'll admit this is an area of the law that employment lawyers don't spend a ton of time in is unemployment. But I've done a little digging to try to figure it out, and what it looks like to me, and this is my understanding, is that you have 20 weeks of eligibility under state law, and that's for someone who goes through those categories that Elizabeth covered while I was kicked off the phone. But the first category of state unemployment, the max eligibility is 20 weeks. The last piece that I covered at the very end of the presentation is the additional 13-week add-on that adds on to that 20 weeks of eligibility for a total of 33. If someone can meet those bullet points for the 13-week add-on, they can get a maximum of 33 weeks of unemployment. Not all that will have the $600 eligibility. That runs out at the end of July. But running through the end of the year, that maximum is 33 weeks if they can meet those last standards. And then if they don't apply or they don't qualify through the traditional state avenue, but they can qualify through the COVID-19 or PUA, the PUA unemployment benefits that Elizabeth covered. If they meet one of the 11 categories, one of which is essentially a catch-all, or they're an independent contractor, or in some cases a business owner or self-employed, in those situations, they'll qualify for 39 weeks. So they'll actually qualify for 6 more weeks than someone going through the traditional state unemployment mechanism. That's something that the state of Missouri is trying to get their hands around. They have one of the shorter sets or numbers of weeks in the country, and so that's why you have that discrepancy there. I think they're going to try to come out with some determination on that issue, and that's more of a wait and see. But for now, it's either the 33 weeks or 39 under the PUA or PUA unemployment benefits.
Okay, thanks for walking us through that, Paul. That is complicated, but it helps a lot just to kind of walk through that. Elizabeth, I'm going to pivot to you now on a question that's related to when an employer, because of a lack of work that's available, has reduced their workforce through a furlough or maybe a layoff, and maybe there may be a distinction here that you can help walk us through. But can the employer continue to maintain benefits that were a part of the employee's compensation arrangement while they are being laid off from pay and then essentially receiving an unemployment benefit for compensation? Can they continue their benefits?
Sure. And this is a really good question, and one that we've actually been receiving from quite a few clients. So, Matt, you brought up a great issue. The terms furlough, layoff, termination, they've been used kind of interchangeably by a variety of people and a variety of media sources. So I want to make sure that we're kind of focusing on what we're talking about and using the same terminology. So when we use the term furlough, that means you're not terminating the employee. You're essentially putting them in an unpaid status. So furlough, you maintain the employment relationship, but the person is put in an unpaid status or on an unpaid leave of absence. When you lay somebody off or terminate them, you're ending the employment relationship. So there's no recall in that situation. With a furlough, you're likely going to recall that individual to come back to work. So focusing in on this question, when you furlough somebody, the purpose of this is really to maintain that employment relationship. Maybe you don't have the work, so you're going to put them in an unpaid status, but maintaining that employment relationship does exactly this. It lets you continue their benefits in most situations. So the most significant benefit that comes up that we've received questions about is healthcare benefits. And what we have advised our clients to do is to make sure you look at your benefit plan documents. So when you're looking at your benefit plan documents for your medical benefits, most plan documents include a period of time where an employee can be in an unpaid status or on an unpaid leave, and the employee can continue on the employer's plan without triggering a COBRA event. Most of the time that period is 30, 60, 90 days, but you want to make sure you're checking your plan documents so you can see how long can I have this employee on a furlough in that unpaid status, continuing to receive benefits before it triggers a COBRA event.
Okay. That's very helpful. And then I think I saw on the poster that Paul shared earlier, another kind of the answer to another related question, which is there's I think some concern if you have a furloughed employee and they're receiving unemployment compensation and you want to call them back, but say because of the enhanced federal benefit, they're making more money right now on the bench, as it were, than if they're back in the game with your team. They can't just decline that and continue to receive the expanded unemployment benefit. They do need to come back when the job is offered back. Is that right?
That's right.
Yes.
Okay. So, and you addressed this also, I think, and I think it's been covered, but just to verify, if someone has a fear of work and they claim concerns, they need some kind of a medical, an underlying medical condition, something that would demonstrate why they can't work in that situation. They can't just be afraid of catching COVID-19.
Right, and Matt, this is Paul. The guidance that is provided on that through the Q&A and also through this poster is not that they're going to provide that medical information to the employer. It says that the worker should provide that doctor's note when filing for unemployment. All the employer is going to be able to do in that situation is respond that there was work available and that they were ready and that the employee was unable or decided that they could not accept that work. It'll be up to the Division of Employment Security to decide whether the justification that the employee has given meets one of the COVID-19 qualifying reasons or has provided this doctor's note that they mentioned in their Q&A and also in this unemployment insurance benefits eligibility. Some of this touches on and gets into the area of FMLA and ADA, and it's much more complex than we're prepared to go into in this presentation. But that's the guidance that has come out from the Department of Labor.
So I guess maybe related to some of that expanded FMLA and sick leave and everything that was part of the earlier relief package, are employees required under any of these provisions to exhaust a certain amount of their PTO or their sick leave or anything like that before filing for unemployment, or are those really unrelated items?
So I'll jump in here. For purposes, and I'm going to answer your question a little bit differently than you asked it, Matt. But
okay.
First of all, for an employee that is trying to use a benefit under the FFCRA, so the unpaid sick leave or the emergency FMLA, employers cannot require them to use PTO first. The employee is allowed to use that benefit under the FFCRA before any paid time off that they have accrued. For purposes of unemployment, I haven't seen anything that would require an employee to utilize PTO prior to receiving unemployment. Usually, if they're going to be eligible to receive unemployment, it's because the employer has said, you're furloughed.
Okay.
If the employee,
and actually,
go ahead.
Actually, I'm going to jump in there on Elizabeth. Elizabeth and I sometimes disagree on a few of these issues, and there is some guidance that if an employee has sick leave or PTO or even vacation available to them, and the employer is making it available for them to use, they are not eligible for unemployment during that time period. So an employer can choose to suspend any of those PTO policies and put their employees on layoff and not allow employees during that time to use PTO. In that situation, they would not be ineligible to receive benefits. But if the employer is permitting employees or expecting employees to use some PTO, in that situation, they're not eligible for unemployment benefits.
Okay. Elizabeth, I'm going to try to explain kind of a scenario that was given to us and just bounce it off of you and see what you think. So if an employer, so here's an employer designated as an essential business. I have an employee that I need to lay off because of their performance. He's currently at home with a child because the daycare was shut down. He also has a partner who is at home and could provide daycare. What are there anything? What am I obligated to do with this new program, and what can I legally do? Can I still lay this person off for performance? At this point, if he was laid off, does he still pull down the extra $600 a week in unemployment, even if it's not technically COVID related? It's more about performance. If he's just off, like he's not laid off, but he's just off work, then do I still have to pay him 2/3 of his average pay and his insurance because of the expanded FMLA? So a lot of different pieces kind of interacting with each other, but it's the core of it is if I need to lay somebody off and it's really more about their performance, but there are all these other dynamics that are at play at the same time, how do I approach that?
Sure. So I'm going to do my best to answer the multiple questions here. So first, let me answer the easy one first. If the employee is off of work to care for their child, but there is another suitable adult that can care for that child, they're not going to be eligible for the emergency FMLA or the emergency paid sick leave. So
okay. Part
of the IRS documentation is that you can require the employee to certify that there is not another adult that can take care of that child. Part of this is going to require employers to really hold their employees accountable, though, to the specifics and the specific guidance that the IRS and the DOL have given us as to what certification we can require from the employee. But it's really just a statement from the employee, hey, there is no other suitable adult. If the employee has already utilized FFCRA, either the paid sick leave or the emergency FMLA, there is language that prohibits employers from retaliating against employees for utilizing these benefits. So there is a possibility and a potential that an employee could claim retaliation for utilizing the benefit. So it's going to be really important that if you are wanting to terminate based on performance, that the documentation to support the poor performance is very strong. You want to make sure that you have that documentation to prove the basis for the termination versus leaving it open to argue that there is a retaliatory motive. This is one that I would say, it would be very important to seek legal guidance as to how strong your argument is for the performance-based termination to make sure you're reducing your risk as much as possible there. On the unemployment question, and Paul, correct me if I'm wrong on this, but my understanding is that if an employee receives, again, we go back to this $1 of unemployment benefits, that they're entitled to that $600 per week. So unless you're terminating for misconduct or some other reason that would make the person ineligible to receive unemployment benefits, my understanding is that they will receive that $600 week's benefit.
That's my understanding as well.
It's more about when it happens, not necessarily tying it directly to a cause and effect, in other words.
Absolutely.
Okay.
Right.
Okay. We're running out of time. We have so many questions. We have more than we will have time to get to, but I want to bounce a quick one. I think a quick one, Paul, off of you. How often does someone have to self-certify that their unemployment is due to COVID-19 in order to get these expanded benefits? Or maybe it's not even the expanded benefit. Maybe it's just so they don't have to keep looking for work in the interim or whatever else. Is that just at the beginning of the period? Do they have to do that weekly? How does that work?
Well, Missouri, and remember, all of these are through submission through the state's program. And Missouri requires employees to go in and request weekly their unemployment compensation. Now, they have said you don't have to show that you are looking for a job if you're out of work due to COVID-19, and you can put 0 in the number of job interviews or efforts to obtain a position. But they do have to go in weekly to request their benefits.
And is that expanded $600 a week benefit? We know there's a July 31 cutoff for that. Do they receive it all the way up to that time? Is it just for 13 weeks if they started earlier, or how does that work?
I haven't done the math on it, but I think it is roughly 13 weeks from when it was first put out there as far as eligibility goes. I believe, and it may be a little bit more than that. I think that the first week of eligibility was last week, and the first week of payment is this, but it is a maximum of 13 weeks. There's been some discussion of Congress expanding that or extending some form of expansion of unemployment beyond what's there, and I think that folks are just watching to see what happens overall with the pandemic to make that determination. But it is a 13-week limit at this point.
Okay. Well, I'll tell you what, like I said, we have more questions, and if we didn't get to your question today, I'm very sorry about that, but please know that we will follow up with you. We have your contact information, and Paul and Elizabeth have been very generous, not only with their time here, but to be able to hopefully help provide us some guidance on some of these additional questions as well. So very, very, very thankful for their time and for their expertise today. So as we wrap up the program today, let me just share, if I could, a couple of important things. First, I know we didn't get to all those questions, but we will continue to seek those answers when possible and follow up with you in the coming days. Big thank you to Elizabeth and Paul for being with us today and for sharing just these great insights and knowledge on very important, relevant topics to employers and to employees right now. You two clearly are a wealth of knowledge, and we had the right people on the call today. That's clear. I also want to thank the Springfield Metropolitan Bar Association for your partnership today, and just thank you, Krista, for working to establish the legal referral program. What a tremendous benefit that is. Thank you for your work on that. That is enormously valuable right now, and I know that resource will be very much appreciated by our small business members as well. We just really appreciate your help, as together we assist businesses in our community as they navigate this crisis. Thanks again to all of our members for joining us today and for your questions. I appreciate you engaging with us and taking the time to be with us on this call today. We know you're working hard to deal with many challenges, and we hope to continue to bring you timely information that's relevant to your most pressing and immediate needs through this process. We're also setting up an educational opportunity in partnership with the Missouri State University Small Business Development Center to that end. That'll be taking an even deeper dive into the Small Business Administration's aid programs with some lending experts, and that's going to be taking place on this Friday, April 17th from 11 a.m. to noon. You can find registration information about that on our website at springfieldchamber.com. And we're so grateful for your membership. Just remember, through all of this, we are in this together, and we are here for you. And thank you for being a part of the Springfield Area Chamber of Commerce and for helping one another out through these difficult times. Thanks so much, everybody. And with that, we'll sign off for today.